14-10417 and 15-10384. Mr. Hernandez is present in court. Will all the parties please identify yourselves for the record?
Good morning, Your Honor. Patrick Hagan for the Commonwealth.
Good morning, Your Honor. Teresa Anderson for the Commonwealth.
Good morning, Your Honor. Mark Mead for the Commonwealth.
Good morning, Your Honor. Jose Baez.
Ron Sullivan on behalf of Aaron Hernandez.
Kenny Bob on behalf of Aaron Hernandez.
George Williams on behalf of Aaron Hernandez.
All right, counsel, let me see you all at sidebar.
With respect to the first element of the intimidation charge, the Commonwealth must satisfy you beyond a reasonable doubt that Mr. Hernandez shot Alexander Bradley on February 13, 2013. We submit that the court got it correct on page 53 of the jury instructions, where the court said, in the context of this charge, the Commonwealth must satisfy you beyond a reasonable doubt that defendant shot Alexander Bradley on February 13, 2013. At issue here, Your Honor, is the difference between a constructive amendment to an indictment, which is not proper and violates due process, and a variance in the language of an indictment for purposes of an instruction, which is permitted by the courts and is not constitutionally infirm. So broadening an indictment triggers due process concerns, but narrowing an indictment to comport with the evidence as admitted in a case is proper and well within the court's discretion. The United States Supreme Court has endorsed this in United States v. Miller, which is the leading case on this issue. In that case, Mr. Miller had been charged with various fraudulent acts in connection with a burglary at his place of business. Specifically, he was alleged to have defrauded his insurer by consenting to the burglary in advance, one, and two, lying to the insurer about the value of the goods. The trial proof, however, only went to the second allegation, lying about the value of the goods, and that's what the court instructed on, the trial court. Ninth Circuit reversed, and the U.S. Supreme Court reversed the appellate court and said that that was proper. In Miller, the court said Miller's indictment properly alleged violations, and it lists the code, and it fully and clearly set forth a number of ways in which the acts alleged constituted violations. The facts proved at trial clearly conform to one of these theories of the offenses contained within the indictment. Your Honor, the court went on to say, accordingly, there could be no showing here that Miller was prejudicially surprised at trial by the absence of proof concerning his alleged complicity in the burglary, nor can there be any showing that the variance prejudiced the fairness of respondent's trial in any other way.
I'm sorry, what was the variance in that case?
The variance was that the instruction only went to the second claim, not the first claim, because that's what the proof at trial.
The instruction went to it. I take it.
I'm sorry. The instruction. And we think that is similar. I'm sorry, Your Honor.
But the form of the indictment was proper.
The form of the indictment was proper.
Okay.
But the courts have said that if the evidence produced at trial is consistent only with one theory of the case, then it is proper for the court to instruct, to vary the indictment in the instructions in that respect. Miller, I'll add, has been cited favorably by the Mass Court of Appeals and Doe v. Sex Offender Registry Board, 85 Mass App 482, and favorably on other grounds by the SJC in Commonwealth v. Vasquez, V-A-S-Q-U-E-Z, 456 Mass 350. There's also a Fifth Circuit case, Your Honor, which presents persuasive evidence and well explains Miller, Your Honor. I'll get that cite to you in a moment. The Mass Supreme Judicial Court also makes it clear that it is proper for the court to instruct to vary the indictment and instruct consistent with the evidence. In Commonwealth against Hobbs, 385 Mass 863, the court said, quote, "We have upheld convictions when the particular terms of the indictment for which the evidence or instructions depart were merely surplusage, unnecessary to describe the crime, and did not mislead the defendant, confuse the jury, or raise the danger of retrial after acquittal." We also cite Commonwealth against Whitehead, 379 Mass 262, and Commonwealth against Grosso, 375 Mass, and I appear to only have the Penn site, 139, but I'll get the full site to the court. So the point here, Your Honor, is that the government proceeded under one theory and one theory alone, and it's the theory that Your Honor memorialized on page 53 in the jury instructions, is that Mr. Hernandez shot Mr. Bradley on February 13th inside of a car in Florida, and did it for the purpose of intimidating him as a witness. The law is clear, of course, that the indirect or implied threat violates the law. Most of the cases deal with threat. That is not a direct threat, but something that is very provocative. The courts call that an indirect threat or an implied threat. So it's not a direct threat, but it's something that is implied. Or the courts use implied or indirect threat to suggest that if to make a claim through some third party that's intended to reach the putative witness, that's also an implied or direct threat. We simply have no evidence of that here. So instruction on that would be mere surplusage. It would confuse the jury, it would mislead the jury, and it would allow the Commonwealth to proceed under a theory for which there has been absolutely no evidence. Starting with the grand jury proceedings, the government proceeded under one theory. At trial, the government proceeded under one theory. Indeed, we made decisions not to cross-examine people or cross-examine people on certain areas because the government proceeded only on one theory, to now open the floodgates and permit the jury to speculate that Mr. Hernandez, I guess the argument would be, ordered somebody to shoot Mr. Bradley, would be to allow the jury to speculate on something for which absolutely no evidence is on this record. So on these bases, Your Honor, we submit that the court should respond by instructing the jury that with respect to the first element, that the Commonwealth must satisfy the jury beyond a reasonable doubt that Mr. Hernandez shot Alexander Bradley on 2/13/13, and that should be the sum total of the response. Court's indulgence. And Your Honor, the cite for Nunez that I didn't have, the Fifth Circuit case, is 180 F. 3rd 227, which again explicates the Supreme Court's language distinguishing between an unlawful broadening or constructive amendment of an indictment and the lawful variance of an indictment to strike surplusage. Now, and finally, just to be crystal clear, the government's theory and loan theory was that Mr. Hernandez alone, not by or through any third party, violated the intimidation statute by shooting Mr. Bradley. And this court's instruction should reflect what proofs came in at trial.
Commonwealth?
Your Honor, Honor, I think the jury's question is just taking note of the difference in the language between the noted numeral 1 element listed and then the further detailed explanation on the first element. I think all that's needed is to mirror the two, which track the statute. As I understand, the indictment in this case also tracks the statute. So the statute appears now in 3 places, and it seems that the one paragraph they're referencing is the sole place that the language directly or indirectly, willfully, and then threatened.
So your answer is the jury can find the defendant guilty if he indirectly, willfully threatened, attempted, or caused physical injury.
Yes, and the jury's
All
been
right.
so
Now,
instructed in 3 places.
Let's talk about the evidence. Under what view of the evidence could this jury find an indirect threat or physical injury?
I think getting as far as the gun in the face is the indirect threat. If the jury finds that someone else did the actual shooting, the gun in the face is enough, and additionally the response the night before.
So the jury could, on the evidence, reasonably infer that Mr. Bradley awoke when the car stopped to see Mr. Hernandez holding a gun aimed at his face, and that is the criminal conduct, period.
Yes,
Then why did we hear all this evidence about a shooting?
because it does go a step further.
Yeah.
And if the jury were to
You're
believe-
asking, or you're suggesting, the jury could find that after pointing the gun at Mr. Bradley, the defendant then passed the gun off to another, and the other then fired it? We have no evidence to support that. I mean, that would be rank speculation.
we have evidence that one person in the car fired the gun at the defendant. There was, again, I think as long as the language tracks the indictment, and I don't dispute
Well, the
that.
language does track the indictment, and the language, the indictment tracks the statute.
Correct.
And the indictment asserts either direct or indirect conduct with the other elements. But the evidence, seems to me, cannot support an indirect, a finding by the jury that the defendant indirectly caused harm to Mr. Bradley or threatened Mr. Bradley through another person.
I think the additional evidence that we could use to get there is the text messages after the fact, in which Bradley states he didn't know who shot him. So adding those pieces together, I think we can get to the indirect. Again, I don't think there's anything wrong with the remainder of the instruction. I think it's simply a matter of alerting the jury that there was, 4 words that were omitted from the copy and paste of the first element into that first paragraph. It tracks the element list that the jury was given separately. It tracks the statute that appears on page 52. And there's nothing further to tell the jury. Certainly our SJC in Commonwealth versus Morose and the appeals court in Commonwealth versus Tejada have interpreted the witness intimidation statute in the 2006 amendments such to broaden the statute and to encompass as full a range of conduct as
yes,
possible.
it does. But the instruction is given in the context of the evidence presented. And the Commonwealth's theory throughout has been that the intimidation was committed by physically injuring Mr. Bradley by shooting him in the face, in the head.
And I think that is what the rest of the instruction states,
Yeah.
and there's no dispute there.
Well,
it's simply mirroring the language.
I think now to suggest, folks, you could find the defendant guilty based on pointing a gun without firing, which, if you find that constituted a threat, would suffice. That may be correct, but it's not the evidence. In either instance, it would require direct acts by the defendant, not indirect acts. So it seems to me basically the correct answer to the question is read the instruction already given. The instruction as to the first element and as explained is correct. You must find beyond a reasonable doubt that the defendant in fact shot Mr. Bradley. I don't see any other way in the evidence that the jury could find another theory of culpability without engaging in speculation. So I think that is the way I will answer this question. To the extent you have an objection to that, it will be noted. Mr. Sullivan, I think that's what you were advocating.
Yes, Your Honor.
You're winning. You want to keep going?
We would just, I do not want to undermine the argument. We would ask that you answer the question in form similar to how you answered the other question. The direct answer is no. You cannot convict Mr. Hernandez on indirect, willful.
Well, if it were a direct question, I would answer it directly. But it's not a direct question. It's we aren't sure if the defendant can be found guilty if we find he indirectly, willfully threatened. I will answer that no, that you cannot find the defendant guilty for indirect conduct. You must find the defendant, in fact, caused, threatened, or attempted to cause physical injury to Mr. Bradley.
Very well.
All right. Why don't we line our jurors up?
All right.
Before the court is the continuation of the trial in the matter of Cromwell versus Aaron Hernandez.
Docket numbers 2014-10417 and 15-10384. Mr. Hernandez is present in court, represented by attorneys Jose Baez, Ronald Sullivan, George Leontire, and Linda Kenny Baden. The Commonwealth is present, represented by Assistant District Attorneys Patrick Hagan, Mark Lee, and Teresa Anderson. Good morning, Your Honor. All 12 members of our deliberating jury and our 3 alternates are present.
Morning, counsel. Good morning, folks. Good morning. Let me inquire of all our jurors, both deliberating and our alternates. Since yesterday afternoon, has any juror discussed this case, read, heard, or seen anything about this case outside of court, or had any contact with the case outside of court? If you have, would you raise your hand? And seeing no hands raised, I find the juror remains indifferent as to all extraneous matters. And we ended yesterday, or close to the end of yesterday, with a question submitted on behalf of the jury by its foreperson that I've reviewed with counsel and that it's appropriate now to address. And the question references indictment number 001 relating to the second indictment in this case, the 2015-10384 indictment charging intimidation of a witness. And the question references further the instructions that I sent up to you folks and that I delivered to you on Thursday. It reads as follows on page 53. We aren't sure if the defendant can be found guilty if we find he indirectly, willfully threatened or attempted or caused physical injury to Alexander Bradley, in addition to satisfying the second and third elements. The explanation paragraph only says, below the 3 elements, only says directly. And rephrasing this into a question form, the question would be, can we find the defendant guilty if we find he indirectly, willfully threatened or attempted or caused physical injury to Alexander Bradley, in addition to the other elements? And the answer to that, in the form of that question, would be no. The law permits that someone violates this statute if they directly or indirectly threaten, attempt, or cause injury to another. So the law permits it. The evidence in this case would not. That is, the evidence presented in this case is that the defendant himself directly threatened or caused physical injury to Alexander Bradley by pointing a gun and then shooting a gun at Mr. Bradley. To construe the evidence such that the defendant indirectly committed that engaged in that conduct would be to engage in speculation. There's no evidence that anyone else committed that shooting or pointing of the weapon, and if you were to find so, that would be beyond the evidence that is before you and any reasonable inferences to be drawn from that evidence. So simply put, I would ask you to, or refer you, to the explanation on page 53 as to the first element of this offense, that in the context of this case and this charge, the Commonwealth must satisfy you beyond a reasonable doubt that the defendant shot Alexander Bradley on February 13. I hope that answers the question. I think that it does. If it does not, or you seek further clarification, please send me a note. And with that said, I'm going to ask our deliberating jurors to resume their deliberations.
All right.
We thought you folks needed some exercise. In the instruction I just gave you, it was pointed out, and I didn't focus on it at the time, that it could be construed that I was expressing a view about the evidence in saying the evidence shows only that Mr. Bradley would have shot this gun. Please understand, I did not mean to suggest that as a declaration of fact in any way. As I've told you, I have no views about the evidence. That's your job, not mine. What I meant to say, and should have said more clearly, is that the theory in this case is that Mr. Hernandez shot Alexander Bradley and no one else. And so it is on that, the evidence supporting that theory, that you must determine whether the Commonwealth has proved its case beyond a reasonable doubt, i.e., that you must find that the defendant and no one else directly threatened, attempted to cause, or caused physical injury with reference to the first element of witness intimidation. I think I've said it correctly this time. Commonwealth, are you content?
Yes, Your Honor.
Defense, are you content?
Defense is content.
Yes?
Yes, sir.
All right. We're all content. Go back upstairs.
All right.